Oh, my seniors, your very last set of notes, and then you'll never take notes ever again. Okay, holiday notes, okay. Except for your entire college career, and then law school,
And medical school.
and then medical school, because, hey, just stay in school forever. But then after that, you're done. That's it, just today. These are the constitutional notes. Now, like I said, I'm going to take this and lump it onto your final exam. So my juniors and my sophomores, I do just want to tell you as well, your Unit 3 exam on Friday is not going to cover this. But your final exam does have this on there. So just be certain that you are familiar with this for your final exam. Now, today, what we're going to have a chance to do is get into First Amendment, and really that's it. But the thing about the First Amendment is, it has several different pieces to it. So it goes well beyond just just one piece. So I always say it like this. For First Amendment, I want you to put this acronym RAPS. R-A-P-P-S. Because in the First Amendment, you have 5 protections. Now, based on this, I will let you guys throw them out there. What do you think the R stands for? Religion, A. Assembly, P.
Petition.
Ooh, good. We usually miss that one. Petition the government. What's the other P? Press. And then? Speech. R-A-P-P-S. Those are the 5 protections you have in the First Amendment. Now, those 5 protections that you have are designed to protect you from prosecution by the federal government. When the Bill of Rights was first written, it had 0 protections from state governments. They could do whatever they wanted. Now, ever since the end of the Civil War, those protections are now placed on federal government and state government. Now, I always kind of get this question, so I just want to answer it right now. If you say something at work, and your boss is offended by it, or he says the customer's offended, or whatever, can he fire you for that? Yeah. Can you take him to court and say I was expressing myself?
You can't.
You can. The court will say, I don't care. Expressing yourself at your job is very different from expressing yourself against the government. You can say whatever you want about the government and they can't come after you because you have First Amendment protection. But like a private business, they can do whatever they want to you. You don't have First Amendment protection from your job at Target. That's not how it works. This is all connected to government power, what they are restricted from doing to you. So they can't throw you in jail for what you say. For the most part. Because there are things that are permissible and some things that are impermissible. The guarantee of freedom of expression does have limits. What we're going to talk about are going to be really 3 big areas where your First Amendment can be limited. Now, it's always very much a balancing act. You have to weigh the individual's rights versus those of someone else, versus the societal order. So I will use this phrase as this is what the court has used as well. When the Supreme Court was asked about how to limit what someone says, the Supreme Court came up with this analogy. They said, you're allowed to swing your fists as much as you want. As long as you are not hurting anyone else, fine. Swing your fist as much as you want. But it's when you come into someone else's nose, thank you, Michaela, for giving me your nose. That's when your rights stop. It's protecting the other individuals around you. So we have 3 big limits on freedom of expression. The first one is what we've already talked about, libel and slander. Now remember, libel and slander are when you lie about someone, and libel is when it's in print, slander is when it's spoken. Now there are going to be some limits to that as well, so I'm going to ask you guys, because we did this a while ago. Do you remember, what do you have to prove for libel and slander? Remember what it was? Even you remember?
Monetary loss.
Have to prove that you were harmed. Yeah, monetarily is usually the way it's done. Sure, Abby, something else?
Reputation is damaged.
Your reputation is damaged, and it costs you financially usually. Sure. Oh, and something else?
It was false.
It was false. Mm-hmm. There's something else in there though too. And what's the one you remember?
It was communicated to a third party.
You're absolutely right. Did someone else overheard it? I think it starts with an M. It was done maliciously. It's a really high standard for this, but it's possible. Now, second thing that can limit your freedom of expression is going to be, does your speech create, and this again from the court, a quote, clear and present danger? Now, this is again kind of a term that is not black and white. It's not very concrete. Because, and a lot of people use this, and this is no longer correct. I bet you guys have heard this analogy. You can't yell fire in a crowded theater. Have you heard that one before?
Yeah.
That was a court case that was decided back in the 1960s. About 10 years later, the court said, that's not good enough. So that phrase, yell fire in a crowded theater, is actually thrown out. That's not the court's standard anymore. Their standard is, does your speech create a situation where imminent lawless behavior is going to happen? So I want to kind of compare and contrast. If you yell fire in a crowded theater, could someone get hurt or someone die?
Yeah.
It could. Is it probably going to happen? This is where the court's in this kind of weird gray area. They threw out that phrase, you can't yell fire in a crowded theater, and replaced it with, is imminent lawless behavior going to happen? Now again, this is hard because how do you know exactly if that's going to happen? So I kind of use the extreme. If you're giving a speech in front of people and everyone's getting riled up and angry and you say, you know what, let's do something about this. Everyone, go get your pitchforks, go get your torches, let's go now and burn down the White House. If it happens, you're in a lot of trouble. Now, what if you kind of say, hey, look, I'm not saying to go do this, but if the White House burns down, I wouldn't be upset. Is that imminent lawless behavior?
No.
This is, again, the gray area. If you say something like that, you're probably going to be protected by First Amendment. Yes, it.
I gotta ask, do you always use that analogy, or is it just because it happened?
I always use that analogy.
Oh, so that was a fun moment for you.
That was interesting. Now, there's going to be something else where there is, in fact, restrictions on expression. But even the court has a hard time explaining what it is. The third restriction is obscenity. Now, when asked to describe what is considered obscene, even the court doesn't really know. So again, I'm going to use one of their quotes. When asked what is obscene, one of the members of the Supreme Court said, I don't know, but I know it when I see it. So they were kind of saying, well, what do you mean? And what often happens is the court is put in this weird spot where they say, well, what is art and what is pornography? So every year, and I kid you not, this happens, every year, the court has what they call movie day. I will leave it at that because I don't want to take this any further. The court will say that is art, that is pornography. It's got to be a weird day on the court, but that's it. That's all I'm going to say. I use this example because this is kind of what the court used as well. This is Michelangelo's statue of the David, where they said that's art. Now you have all these people say, well, how is that art versus movie day? And the court just goes, I don't know. Just is. Now, I think a rational person would agree and say, yeah, that's art. It's not what happens on movie day. But when asked to define it, the court said, you know what? I'm not even going to try to define it. I'm just going to leave it up to other people. Basically, what they are asked is what is art and what is obscenity? The court punts. And they say, we're not going to put a limit on it. We're not going to define it. We're going to let local entities decide in their area what is art and what is obscenity. So I always use this example too. Is it possible that if you take the same work and show it to someone in New York and show it to someone in Utah, you might get a different response? If you haven't been to Utah, it's a lovely place, but it's very different from New York. So it's possible if you go to Utah and you show them a picture of the David, they might say, that's pornography. And the court says, fine. Local areas determine what's acceptable for them. That's the weird kind of dividing line. Now, as far as going beyond just what restrictions are, I want to talk specifics here. Now again, all of these can be limited, but the court is very careful about how they limit expression. Because when you start to limit it, you chip away at it. And when you just start to chip away, it opens the door to more restrictions. So what we're going to talk about is going to be after speech is assembly. Yes, sir.
So, for example, the reporter finds out, like, where a bunch of military bases are located or whatnot that are supposed to be covert. Could, like, the government essentially slap NSA or national security tag on it and say, don't believe it?
It's what's called prior restraint. They can say, we can't stop you from printing this, but don't print it now, because you would put them in danger. You can print it later, just not now. It's for protection. Now, as far as assembly goes, there's kind of just one real big way to paint this. And this is really what the court has said the founders intended. The idea of freedom of assembly is you can gather with others to make a statement. Now, if you're making a statement that is not political in nature, your assembly can be restricted further. So actually, this was kind of the perfect year for this. Do you remember when, and this is actually still kind of going on to a certain extent, when the government said you are not allowed to gather with anyone else outside of your immediate household? That's the restriction. Now, when I first heard that, I was thinking about this, and I thought, you're going to get a ton of lawsuits. As of right now, we haven't really seen any. But I could make a very good argument that when the government says you can't get together with people, that's a First Amendment violation. Easy. Now I'll ask you guys, in the time that we are living, you think the court might say, yeah, in a normal time it would be a violation, but not right now?
Yeah.
They could. Now if it's a political statement, you get kind of further protections. Because what you're trying to do is voice your displeasure about the government. So no matter what your message is, no matter how offensive it might be, you still have the right to gather. You still have freedom of assembly. So this is always kind of this bizarre situation the court finds themselves in every single year. There are groups that want to dissolve the federal government. They get protection for gathering. But you can't just all of a sudden come together like a mob. What the court is very clear about is we need to have some kind of law and order here. We need to have some